Imagine you filed your green card application 2 years ago. You did everything right. You paid the fees, you submitted every document, you went to your biometrics appointment, and then, nothing. Silence. Weeks turn into months, months turn into years. You check your case status online every single day, and it says the same thing. Case is being actively reviewed, but nothing is happening. Meanwhile, your life is on hold. You cannot change jobs, you cannot travel, you cannot plan your future. And every day you wonder, is my case lost in the system? Did they forget about me? Will I ever get an answer? If this sounds like you, then you are not alone. As of April 2026, USCIS has a staggering 11.6 million pending applications sitting in their system. 11.6 million. That is not a typo. NPR confirmed this number in their April 2026 investigation. The American Immigration Council reports that the backlog has more than tripled over the last decade. The average processing time for a green card application is now 6 to 10 months. For some categories, it is 28 to 32 months. And with new enhanced vetting procedures requiring fingerprint resubmission for pending cases, delays are only getting worse. But here is what most people do not know. You are not powerless. There are legal tools available to you right now that can push USCIS to act on your case faster. These are not tricks. These are not hacks. These are official government processes that exist specifically to help people whose cases are stuck. In this video, I'm going to reveal the 5 legal methods to speed up your pending USCIS case, ranked from easiest to most aggressive. I will tell you exactly how to use each one, when to use it, what evidence you need, and what results to expect. Most immigration attorneys charge hundreds of dollars for this information. I am giving it to you for free right now. Let's get into it. Before I give you the 5 methods, let me first explain how to know if your case is actually delayed or if it is still within normal processing times. This step is critical because USCIS will ignore your requests if your case is not yet outside normal processing time. Go to the USCIS processing times page at egov.uscis.gov/processing-times. Select your form type. Select your category. Select your office or service center. It will show you 2 dates. The first is the processing time range. The second is the receipt date for case inquiry. If your receipt date is older than that case inquiry date, then your case is officially outside normal processing time. That means USCIS acknowledges your case is taking longer than it should. Only then should you use these methods. If your case is not yet outside normal processing time, be patient. But save this video because the moment your case crosses that threshold, you need to act immediately. Method number 1. Submit a case inquiry through the USCIS e-request system. This is the easiest and fastest first step. It costs $0 and takes about 10 minutes. Here is how to do it. Go to egov.uscis.gov/e-request/ccpt. This is the official USCIS case inquiry page. Enter your receipt number and your receipt date. If your case is outside normal processing time, the system will allow you to submit an inquiry. USCIS calls this a case outside normal processing time inquiry. When you submit this inquiry, USCIS is required to respond. They may tell you your case is in line for processing. They may tell you there is a hold due to background checks, or they may actually take action and move your case forward. Either way, it creates an official record that you have notified USCIS your case is delayed. What to expect? USCIS typically responds within 30 days, but it can take longer. This method alone resolves about 15 to 20% of stuck cases, because sometimes all it takes is someone at USCIS actually looking at your file. Source: USCIS official processing times page and e-request system. Method number 2. File an expedite request. This is more powerful than a case inquiry, but requires you to meet specific criteria. It costs $0 to file, but you need strong supporting evidence. USCIS has published official criteria for expedite requests on their website. You may qualify if you meet any of the following. Severe financial loss to a company or person. For example, if you will lose your job without work authorization, and that job loss will cause severe financial hardship. Emergency or urgent humanitarian situation. This includes serious illness, disability, death of a family member, or extreme living conditions. Nonprofit organization requesting expedition for a beneficiary whose services are urgently needed to further cultural or social interests. A U.S. government agency requesting expedition because of public interest or national security, or a clear USCIS error that created an urgent need for correction. How to file. Call the USCIS Contact Center at 1-800-375-5283. Tell them you want to submit an expedite request. Provide your receipt number and explain which criteria you meet. You can also submit through your USCIS online account using the secure messaging feature. Select Expedite as the reason for your inquiry. Critical tip: you must provide documentation. A request without evidence will be denied. If you claim financial hardship, provide bank statements, employer letters, and bills showing your situation. If you claim medical emergency, provide hospital letters and doctor's notes. The stronger your evidence, the higher your chances. What to expect. USCIS reviews expedite requests on a case-by-case basis. There is no guaranteed timeline for a decision, but if approved, your case jumps ahead of others in line and gets processed faster. If denied, you can try again with stronger evidence. Source: USCIS Policy Manual, Volume 1, Part A, Chapter 5, and USCIS Official Expedite Requests page. Method number 3. Request a congressional inquiry. This is one of the most underused and most effective tools available to every person living in the United States. Most people have no idea this exists. It costs $0. Here is how it works. Every member of Congress, whether senator or House representative, has a constituent services office. Part of their job is helping constituents deal with federal agencies, including USCIS. When a congressional office contacts USCIS on your behalf, USCIS is required to respond to them. Your case gets flagged and reviewed. How to do it. Find your representative at house.gov or your senators at senate.gov. Look for their constituent services or immigration help page. Most offices have an online form specifically for immigration case inquiries. Fill out the form with your name, receipt number, a brief explanation of your situation, and a signed privacy release form, which allows the congressional office to access your USCIS records. The congressional office will then send a formal inquiry to USCIS on your behalf. USCIS has an internal deadline to respond to congressional inquiries. This forces your case to be reviewed by a real human being rather than sitting in a queue. What to expect. Response times vary, but most congressional offices report getting answers from USCIS within 30 to 90 days. In some cases, this is enough to get your case unstuck and moving again. Even if USCIS cannot immediately approve your case, they will provide a status update explaining what is causing the delay and what needs to happen next. This information alone is often invaluable. Important note: a congressional inquiry does not guarantee approval. The congressional office cannot tell USCIS to approve or deny your case. They can only ask USCIS to look at it and respond. But the fact that a member of Congress is asking often gets results. Source: U.S. House of Representatives and Senate Constituent Services Guidelines. Method number 4. File a case assistance request with the DHS Ombudsman. The CIS Ombudsman is an independent office within the Department of Homeland Security, whose specific job is to help people resolve problems with USCIS. They can intervene directly and recommend solutions. This costs $0. How to file. Go to dhs.gov/case-assistance. Submit DHS Form 7001, Request for Case Assistance online. You will need to provide your receipt number, a description of your problem, what steps you have already taken to resolve it, and supporting documentation. Before you file with the Ombudsman, you should have already tried USCIS customer service tools, such as the Case Inquiry and Contact Center. The Ombudsman is designed as a next step when those tools have failed. What the Ombudsman can do. They can bring your issue directly to USCIS attention. They can recommend that USCIS take specific action. They can identify systemic problems and push for resolution. They serve as a bridge between you and the agency. What to expect. The Ombudsman cannot approve or deny your case. They cannot override USCIS decisions, but they can push USCIS to actually look at your file and take action. Processing times for Ombudsman inquiries vary, but many cases see movement within 60 to 120 days of filing. Important update for 2026. Some reports on Reddit suggest the Ombudsman Office faced staffing cuts in 2025. Response times may be longer than in previous years, but the office is still operational and still accepting case assistance requests. Source: DHS Official Case Assistance Page and DHS Form 7001 Instructions. Method number 5. File a mandamus lawsuit in federal court. This is the nuclear option. It is the most aggressive, most expensive, and most effective method available. Use this only after you have tried everything else, and your case has been delayed for an unreasonably long time. A mandamus lawsuit is a legal action filed in federal district court asking a judge to order USCIS to make a decision on your pending case. You are not asking the court to approve your case. You are asking the court to force USCIS to stop ignoring you and actually make a decision one way or another. When to consider mandamus? Your case has been pending significantly longer than normal processing times. You have already tried case inquiries, expedite requests, congressional inquiries, and the Ombudsman. USCIS has not provided any reasonable explanation for the delay. The delay is causing you real harm, such as inability to work, travel, or maintain status. How it works: you hire an immigration attorney who files a complaint in federal court naming USCIS and the specific officials responsible for your case as defendants. Once USCIS receives the lawsuit, they are forced to respond through their legal counsel. In the vast majority of cases, USCIS settles by simply adjudicating the pending case rather than fighting the lawsuit in court. Cost and timeline. Mandamus lawsuits typically cost between $3,000 to $10,000, depending on the attorney and complexity of your case. According to Gozell Law, most cases see USCIS take action within 1 to 2 months of filing. One immigration law firm reports a 95% success rate over the past 5 years, with over 2,000 successful mandamus cases. What to expect? After you file, USCIS usually processes your case within weeks to avoid the lawsuit proceeding. The government rarely fights mandamus cases in court because it is cheaper for them to just process your case than to pay their lawyers to defend the delay. Important caveat: mandamus forces USCIS to make a decision. That decision could be an approval or a denial. If there are legitimate issues with your case, such as background check flags or missing evidence, mandamus will not fix those problems. It will just force USCIS to tell you what the problem is. Source: Federal Mandamus Statute, 28 U.S.C. 1361, and multiple immigration law firm case data from 2026. Let me give you the correct order of operations. Do not jump straight to a lawsuit. Follow this sequence. Step 1. Check if your case is outside normal processing time. Step 2. Submit a case inquiry through the e-request system. Step 3. If no response in 30 days, file an expedite request, if you meet the criteria. Step 4. Simultaneously contact your congressional representative's office. Step 5. If 60 to 90 days pass with no results, file with the DHS Ombudsman. Step 6. If all else fails and months continue to pass with no action, consult an attorney about mandamus. Most cases get resolved somewhere between steps 2 and 4. Very few people actually need to go all the way to a mandamus lawsuit. But knowing that it exists and that it works gives you power. One final tip: document everything. Every call you make to USCIS, write down the date, the time, the name of the agent, and what they told you. Every form you submit, save a copy. Every response you receive, save it. This documentation becomes your evidence if you ever need to escalate to higher methods. If this video helped you understand your options, share it with anyone you know whose case is stuck. There are 11.6 million pending cases right now. That means millions of people sitting in silence, waiting, wondering. They deserve to know these tools exist. Hit subscribe and turn on notifications. I cover every USCIS update the moment it happens. Drop a comment below and tell me how long has your case been pending and what form type is it. I read every comment, and I may be able to point you in the right direction. Stay informed, stay prepared. I will see you in the next one.